Today, I want to talk about a Supreme Court decision that a lot of people are either celebrating too early, panicking too hard, or completely misunderstanding. And the reason I am calling this breaking is not because the court suddenly erased the Second Amendment or handed the government a blank check to take guns. It's breaking because the court just clarified the rules of the game for how gun laws get judged going forward. And at the same time, another major Supreme Court case is reshaping how we think about First Amendment pressure campaigns that happen behind closed doors. So in this video, we're going to do something the news rarely does. Slow down, keep it simple, and separate the emotional headlines from what the court actually did. The center of this story is a case called United States versus Rahimi. The Supreme Court decided it by an 8-1 vote. And yes, it surprised a lot of people because it was the party line kind of case that social media often expects. The court upheld a federal law that can make it a serious crime for certain people under a domestic violence restraining order to possess a firearm. But here's the most important part. The court did not say any restraining order means you lose your gun rights. It did not say civil paperwork equals lifetime gun ban. And it did not create a new power for states to instantly disarm anyone based on an accusation alone. What the court did was narrower and more specific. And that's exactly why it matters so much. Because when a Supreme Court decision is narrow, it becomes a template that lawyers and judges will use to argue about magazine limits, assault weapon bans, sensitive places, and permit rules for years. And if you're a gun owner, a future gun owner, or honestly just a person who cares about constitutional rights, you need to understand the template. Let's start with the basic facts in plain English. Rahimi involved a federal law, 18 U.S.C. paragraph 922G8. This law says that if you are subject to a certain kind of domestic violence restraining order, one that meets specific legal requirements, then having a gun can be a federal felony. Not a ticket, not a misdemeanor. A federal felony that can put you in prison for up to 10 years. That shocks people because many Americans mentally separate civil court from criminal court. They assume civil court is just paperwork, money disputes, or family issues. But federal law doesn't always care about that mental separation. Under this statute, the trigger is a civil protective order that contains certain findings and protections. And once that trigger happens, gun possession becomes a federal crime. And here's some major reason this case matters. A lot of people don't even realize this law exists. They think, I'm not convicted of anything, so nothing can happen. Or they think, it's just temporary, it's just family court, it's not real criminal law. But ignorance of the law is not a defense. You can be a normal working person who has never been arrested, and if you mishandle a protective order situation, you can step into federal criminal territory without even realizing it. In Rahimi, the legal question was whether paragraph 922G8 violates the Second Amendment. After the court's 2022 decision in New York State Rifle and Pistol Association versus Bruin, gun laws are tested using a history and tradition approach. The government has to show that a modern gun restriction is consistent with this country's historical tradition of firearm regulation. Now, before Rahimi, a lot of people were arguing about what Bruin really meant in practice. Some courts and commentators pushed an extreme version. They acted like the government has to find an almost identical law from the 1700s or 1800s, basically a historical twin. Rahimi pushes back on that. The court accepted that the government doesn't always need a perfect match. It can use a historical analog, meaning something similar in principle, even if it isn't identical in wording or technology. That might sound like boring legal talk, but it's a huge deal. Because twin versus analog changes outcomes. If you require a twin, lots of modern laws fail. If an analog is enough, more modern laws survive. In the Rahimi opinion, the court said history shows a tradition of temporarily disarming people who are found to pose a real threat of physical violence. People who are dangerous, not just unpopular. The court pointed to historical practices like surety laws and going armed laws as analogs that allowed restrictions when someone posed a threat. The key idea was, when a court has made a finding that someone is a credible threat, disarming them fits within historical tradition. Source. Now watch this carefully, because this is where many headlines mislead people. The court did not say restraining orders are always reliable. The court did not say every protective order is automatically enough. The court repeatedly treated this as a narrow decision tied to the specific features of the federal statute. That federal statute, paragraph 922G8, requires due process elements. It applies only when a protective order was issued after notice and a hearing, and when it includes certain findings or language. In other words, the person has to have had a chance to show up and defend themselves. And the court has to issue an order with specific content. Source. So if you see someone claiming the court said anyone accused of domestic violence loses gun rights, That is not what the decision says. What it supports is the idea that when a court, after notice and hearing, finds a person poses a credible threat to the physical safety of another person, Congress may temporarily restrict that person's firearm possession. Source. And that phrase, credible threat, is not casual English. It's legal language. It means the judge isn't just rubber stamping a complaint. It means there must be a legal process and a finding tied to danger. At the same time, let's also be honest, civil courts can move fast. People sometimes don't take the paperwork seriously. And some people ignore hearings because they think it's not criminal. That's one of the biggest traps. If you ever get served with a restraining order or protective order paperwork, the worst move is pretending it's nothing, even if you believe the other side is lying, even if you believe it will blow over, even if you think you'll talk it out later. The correct move is to treat it as potentially life-altering, because it can be. And this is not only a gun people issue, this is a due process issue. Because anytime the law allows a civil order to trigger a criminal penalty, the details matter more than the vibes. If you're getting value from this breakdown so far, do me a favor in your own unique way. Tap the like button like you re-stamping approved on clear information. Hit subscribe so you don't miss future legal updates that actually make sense, and share this with one friend who only gets their news from clips and captions. Now, let us move into what I think is the real long-term impact, how Rahimi changes the Bruen framework. Here's the simple version. Bruen said, if the Second Amendment covers the conduct, the government must justify the regulation by showing it fits the nation's historical tradition of firearm regulation. The fight has been, how close does the historical match have to be? Rahimi makes it easier for the government than the perfect twin approach, because it explicitly accepts analog reasoning. That doesn't mean the government wins every case. It means the government has more room to argue. So imagine the next wave of cases. Magazine capacity limits, assault weapon bans, sensitive places, expansions, permit and training requirements. All of those cases are going to be argued with analogs, not identical historical twins. That matters, because almost no one in 1791 was debating modern magazines, AR-style rifles, or the current urban policing model, so courts are forced to reason by analogy. Rahimi basically tells lower courts, stop demanding an impossible time machine. Look for historical principles that are relevantly similar. Source. For people who want stronger gun regulations, Rahimi is a relief because it shows Bruen doesn't automatically strike down every modern gun law. For people who want maximum gun rights, Rahimi is a warning sign because it suggests Bruen is not a guaranteed delete button for regulations. But for almost everyone, Rahimi is a reminder that constitutional rights are not judged by slogans. They are judged by legal tests. And the test just got clarified. Now, let's talk about the federal jail point you included in your main message, because it's not hype, it's real. Under Part 922G8, if you are subject to a qualifying restraining order and you possess a firearm, that can be charged as a federal felony. People hear felony and think it only happens to hardcore criminals, but federal gun statutes are often built around status, paperwork, and technical conditions. That's why you can't be casual about it. A person can think they are doing everything right because they are not a felon and not convicted. Yet one family court order with the wrong wording, ignored hearing notices, or misunderstanding of what they are allowed to possess can change everything. And here are 3 mistakes that show up again and again. First mistake, not reading the order word for word. People skim it, or they rely on what a friend said, or they assume the police would warn them. But the paper is the rule. The paper is what the federal government will point to. Second mistake, treating civil court like it's not serious. This is the most dangerous misunderstanding. A civil judge can make findings that have criminal consequences. Third mistake, social media behavior during disputes. People post threats, jokes, screenshots, or angry rants while a protective order is pending. That can turn a weak case into a strong one. It can also be used to argue you are a threat, even if you think you're just venting. So if you want practical protection steps, here they are in plain terms. Take notice seriously. Show up to hearings with counsel if possible. Don't communicate in ways that can be framed as threats. And if you're involved in a dispute, keep your public posts boring and quiet. This is what your theme means in real life. Being informed is protection, not because it makes you right, but because it keeps you from stepping into a legal minefield. Now, I want to be careful here and say something clearly. If someone is truly a credible threat, the law is allowed to intervene to protect victims. Rahimi recognizes that principle and says it has historical support. Source. But it also shows why due process and careful judicial findings matter, because the power to disarm someone, even temporarily, is serious. That's why the legal requirements matter. It's why notice and hearing matter. It's why the order's language matters. And now let's zoom back out to the national impact. After Rahimi, expect both sides to cite it. Regulation supporters will cite Rahimi to argue, the court allows disarming dangerous individuals. The court accepts analog reasoning. Not every law needs an identical historical twin. Gun rights supporters will cite Rahimi to argue, the court emphasized narrowness. The court focused on credible threat findings. The court did not approve broad disarmament. The court still requires history and tradition. And the winners in future cases will often be the side that can frame their law or their challenge in terms that fit the analog approach better. This is why you should expect a new phase of litigation. More arguments will shift to what counts as a proper analog, how close the similarity must be, and what level of generality is allowed. So when you see the next headline saying, Supreme Court just ended Bruin, or Supreme Court just saved all gun laws, you'll know to pause, because reality is more technical than that. Now, before we wrap, I want to connect back to the First Amendment piece one more time, because this is where people miss the bigger pattern. If a government can't easily win through direct bans, it may try indirect pressure. That's why cases like NRA versus Vullo matter. The court made clear there is a constitutional line. Government officials cannot threaten or coerce private parties to punish speech or association the government dislikes, source. And that matters not only for the NRA, not only for gun groups, but for any advocacy group, any controversial speaker, any lawful industry that becomes politically unpopular. If you care about free speech, you should care about that line. If you care about the right to keep and bear arms, you should care about both the direct rules and the indirect pressure points. Because in modern America, power doesn't always show up as a law. Sometimes it shows up as a phone call, a friendly reminder, or a regulatory hint. And that brings us back to the core message. Misunderstand the law, and it can take your freedom. Understand the law, and you can protect yourself and make better decisions. If you made it this far, you're already ahead of most people on social media. So here's your action step. Hit, like if you want more simple English breakdowns of Supreme Court rulings. Subscribe, because the next case will be even more confusing without context. And share this video so the people around you stop reacting to headlines and start reacting to facts. Let me close with a simple summary you can remember. Rahimi did not erase the Second Amendment. Rahimi did not give a blank check for mass gun confiscation. Rahimi upheld one specific federal restriction tied to domestic violence restraining orders that involved due process and credible threat findings. And it clarified that courts can use historical analogs, not perfect historical twins, under the Bruin framework. Source. At the same time, the Supreme Court's reasoning in NRA verse Vullo reminds us that the First Amendment is not just about what government bans directly, but also about what government pressures indirectly through its power over regulated industries. Source. And for regular people, the practical lesson is simple. If you're ever served with a protective order, do not treat it like a minor inconvenience. It can have major consequences, including federal criminal consequences, depending on what the order says and how the process plays out. Stay informed, stay calm, stay lawful, and never let a headline do your thinking for you.